legal injury. I didn't catch it. These first. Economic forms. Employers are typically held liable for the torts committed by their employees. And more importantly, this does not absolve the employee or employer of liability. Whether both employer and employee share joint and several responsibility, they are liable for the injuries and damages that they cause. So the private employers are typically held liable for the torts committed by their employees. Importantly, it doesn't absolve them of their liability, whether both the employer and employee share joint and several liabilities towards the plaintiff. In this case, further harm occurred during the course of employment due to the reliance upon disclosure of information, basically it's publicly available information, and the fact that the plaintiff is ignorant of such concealed facts. They tend to seek recovery from the employer, who is better equipped to satisfy his judgments, except if he would have been informed by the defendants and knew that they were bound to disclose, and they disclosed the facts, the plaintiff would not have taken a detrimental position. As a part of the code, in the California Government's Code section 895.4, as a part of any agreement, the public entity in California may provide for contribution or indemnification by any or all public entities that are parties to the agreement upon any liability arising out of the performance of the agreement. And they are former or current employees of the same employer, the County of Los Angeles Board of Trustees, as they are subject to the Secretary of State of California, and they control the treasury of the state of California, as California admitted in writing on several times, and the whole damn law firm is included, and every one of their associates are members of the employer. So they are self-insured. Equitable principles guide the relief that's sought, although the complexity lies in assessing the various factual indicators, such as the extent of the defendants and the control of the agent which they have over their employee and the nature of the work that's performed. Additionally, the requirement for full indemnification in certain events that further impacts the resolution of the matter. And here, as a negligent misrepresentation pertaining to the information they are legally bound to disclose. Instead, the information is improperly used for personal or professional reasons in connection to property with the representation of their current or former client. It becomes improper and abusive to the ends where the deliberate misrepresentation of the office is used others related to their rights and personal and private property. Real, personal, and mixed are used as means to induce belief in those who depend and trust those who are put in positions of power and who control the means to carry out the acts and omissions and cover up any scheme and operation that is likely to cause harm to others whose products that are of service are, in any event, acts or omissions that occur within the scope of their employment would not otherwise be within the scope of the employment. A bunch of legal mumbo jumbo.
Certainly. Let's break down the legal concepts and principles involved in this scenario. Legal injury. A legal injury refers to harm suffered by a person due to an act or omission committed by another individual. It can give rise to a civil tort claim or criminal prosecution. In California, a negligent act or omission is considered a breach of the duty of care to prevent harm to oneself or others. Different forms of legal injury include permanent injury. This type of personal injury has a lasting adverse effect on employment potential. Irreparable injury. Harm that cannot be cured or reversed by monetary compensation, e.g., pollution of a river. Employer liability and Respondeat superior doctrine. Employers are typically held liable for torts committed by their employees during the course of employment. The Respondeat superior doctrine holds that employers are responsible for their employees' actions within the scope of employment. Importantly, this does not absolve employees of liability. Both employer and employee may share joint and several responsibilities for injuries and damages caused. Additional factors. Comparative fault. When the plaintiff's own actions contribute to the harm, comparative fault may reduce the defendant's liability. Public entity agreements. Under California Government Code Section 895.4, public entities may provide for contribution or indemnification among themselves for liability arising from performance agreements. Negligent misrepresentation. If an employer fails to disclose legally required information and the plaintiff suffers harm as a result, they may seek recovery from the employer. Equitable principles. These guide relief sought, considering factors like control over agents, nature of work performed, and full identification requirements. Deliberate misrepresentation. When information legally bound to be disclosed is improperly used for personal or professional reasons, it becomes abusive. Misrepresentation can harm others' rights, personal property, and trust. Acts committed out of fraud, misrepresentation, or concealment are not superseding causes. Remember, legal matters can be complex, and seeking professional legal advice is essential for specific cases. If you have further...
Well, that's funny you told me to seek legal advice. Speaking that I point out the conflicts of interest, they won't talk to you.
I apologize if my previous response caused any inconvenience. If you have further questions, I recommend consulting a legal professional who can provide personalized advice. Thank you for understanding.